Welcome to the special webinar titled Change a Virus, Anticipating and Proactively Avoiding the Adverse Legal Effects of this New Pandemic. My name is Frank Musica, and I'm one of the risk management professionals in the Education and Practice Management program at Victor. Today we have a special program for you. We are hosting a webinar created and delivered by two or perhaps three of the nation's leading attorneys who defend design firms insured in the CNA program and who provide advisory and transactional services for design firms such as yours. The law firm is Copeland, Stair, Kingma Lovell, which has offices throughout the Southeast. And leading the presentation today is Stair. Kent has over 4 decades of working with design firms and brings an unmatched perspective on how firms get into trouble and what they can do to minimize their exposure. With him today is Tawny, Mack, and perhaps Paul Sperry. Paul is an expert in construction litigation and manager of the firm's Charleston office, but he's actually actively practicing law right now and may not be able to join us. And Tawny is a partner in the firm and works on design and construction industry issues out of the firm's Atlanta office. We hope to be able to answer most of your concerns during this 90-minute webinar. But if you have a specific question, you can ask. You will see a chat box on your screen, and you are welcome to type in a question. If our speakers do not cover your issue in our presentation, we might have time near the end of the webinar to respond as best we can. I do want to apologize in advance for any glitches we might have in conducting this program and for the less than perfect sound quality. As you are, we are operating remotely, so trying to coordinate a webinar can be a challenge. I do need to mention that this program is registered with the continuing education system of the American Institute of Architects. It is a 1.5 learning unit program. After this webinar, you will receive a survey. If you identified your firm as a policyholder, your survey will include information on our reporting of your participation to the AIACES office. We can also provide you with a certificate so you can self-report your involvement in this webinar. If you are not a policyholder, you will receive a survey, but we cannot provide you with continuing education credits or a certificate unless you pay a filing fee of $50. We do want everyone to complete the survey since you can provide us with information on the value of our efforts. I also want to remind you of our website information and our blog posts. I think one COVID-19 post is new today and another one will be posted later this week. And with that, I'm going to turn the program over to Kent and his team.
Thank you very much. Thank you, Frank. This is Kent Stair, and I've got Tawny Mack with me. And as Frank mentioned, Paul may be practicing law today and may not be able to join us. But as Frank mentioned, for 40 years, I have represented design professionals of every type in every kind of situation you can get. And over that period of time, I have the distinction of having never seen a project that went well, because no one ever calls me to tell me that things went great on a project. Every project that I have ever seen over 40 years has always become a problem. And so if today I sound like I'm paranoid about things that might happen, that's the life I live. And one time I learned from an architect friend, he had a writing on the board that said, a wise man learns from his mistakes, a wiser man learns from the mistakes of others. The good news is I have learned a lot of mistakes from others. And what I want to do today is try to share some of those experiences and thoughts with you. And I have focused on change over the period of time as sort of the controlling factor for claims, because things generally go well as long as things go as everyone thought they were going to go. But it's when the things change that the problems occur. And of course, as we know, things are always changing. And then when the coronavirus came around, it occurred to me that this is a change that, unlike every other thing that can happen, was absolutely, totally unforeseeable. And so there's simply no set of circumstances in the course of the project or its anticipation or plan that could have conceived of this kind of thing happening. So I thought, let's just focus on what this kind of change may do, hence the name change of virus. And what we want to do today is try to look into the future and look at the present and see what you might do to protect yourself going forward. And so we will start here, hopefully, if I can get this machine to go down. There you go. And what I do is I like to start with a stage. So a client will come to you and they'll say, we want the project. We've got up there to the right, the project of that we're going to be focused on is the World Trade Center. It's any other building in any other place. It's any other kind of project. Could be a civil project, could be a structural problem. It's a project. And they set it up and they say, we need to have this done within a budget and within a schedule and at a quality that we can all anticipate. And I like to view things going from left to right. I mean, it's just sort of the way I see things chronologically, and it's the way I see things on a project. And so we're going to take our project today. We're going to start in San Francisco, and we're going to go to New York, and we're going to go across the country. And we've set our boundaries, and we've set the top boundary as the Canadian border, and that's the budget. And you have to stay under the budget. And then you have to get there on time, and that is going to be the Atlantic coast. And if you get wet, by way of salt water out there, you have failed in your mission. And then we're going to have to keep it above a certain quality. And so we've got the Mexican border, and the Gulf of Mexico is going to be our border. And so every project ought to be a trip that goes across the country from left to right. It winds up where it ought to wind up, as it should wind up, and it winds up in the lower 40 continental United States. And if that happens, then generally speaking, the project is a success. If you go outside any of those boundaries, and generally once you go outside one of the boundaries, you tend to find yourself outside more than one, then you've got a problem. And so that's the stage, and that's the project that we're going to be talking about today. Now, how do you get from where you start to where you're going to finish? In the olden days, they'd send somebody out on a horse and look, see what was in the future, in the foreground. We're fortunate now. You just turn on your phones, you put it on Waze, and Waze will tell you how to get there. And as you go, Waze will tell you what problems you're about to encounter, and Waze will tell you how to avoid it. And so Waze has made the life of travel a lot easier. And what I'm going to encourage you to do today as you go forward on this trip that we're going to take is to put your design Waze on, because you're going to have to see into the future in ways, if you don't mind my saying that, you have not had before. So we're going to figure out how you get from point A to point B. And I like to quote philosophers, and Clint Eastwood, of course, is one of the great ones. And his Dirty Harry, he said, a man's got to know his limitations. Well, I'm happy to tell you I know mine. And what I'm not going to be able to do is discuss all the variety of project delivery methods that you all use. I'm not going to be talking about the different kinds of projects, contract forms, or every situation. I'm not going to be talking about it. And we may use an architect simply because it's an easy standard to use, but everything I can say is applicable to you engineers who are the prime. It's applicable to everybody who's a sub-consultant, because you're all on the same team and you're all in the same boat, and you need to be aware of the same thing. So we're going to be talking generically about a standard kind of project going from left to right across the country using a standard set of documents. And then what you're going to have to then do is extrapolate from there to your own situation, to your own project, to your own contract. But what I want to do is just give you things to think about. So as I say, I'm going to shoot up a flare, a shot across the bow, if you will. And we're going to encourage you to do three things as you go. You want to anticipate what's ahead. You need to communicate as you have never communicated before about what's going on and what you're going to do and how you're going to do it. And then you need to document. Now, you say, well, those are the things that I've always supposed to have done and always been told to do. You're absolutely right. There's nothing magical about the moment other than it's a totally unimaginable moment. And you need to apply the rules now that you've been told in the past in ways you've never done. And if you don't, I can tell you coronavirus may or may not get you, but the impact of it will, and that's what we want to try to avoid here today. All right, now, what's the deal? You always have to know what the deal is, and the AIA sets it out by telling you the initial information. You put out the program, the characteristics, the budget, cost of the work, design dates, and there's a few design dates that we want to keep an eye on. Is the design dates, the construction commencement dates, substantial completion dates, and then other milestone dates. So in the beginning, everybody sort of establishes the parameters of the trip. They establish what the numerical numbers are that are associated with those boundaries that we drew around the United States, and it all has to be done in the beginning. And so a lot of that is a given. As it relates to the initial information, parties recognize it may change, and it may materially change. And my suggestion is what has happened with this coronavirus is a material change. And in that event, the parties may adjust your services, the schedule for your services, and your compensation. And the owners shall adjust the budget, the cost of the work, and other milestones as necessary to accommodate material changes. Well, we all know there are going to be material changes. What we don't know is how they will be dealt with, and what you need to know is your head needs to be looking at those material changes and working with them as you go. Don't wait until the end to find yourself out in the water or up in the cold or down in the heat. Keep up with the changes as the trip goes on and react to them. Now, as it relates to your schedule, and schedules are very important because a schedule not met results in a delay. And as I'll speak in a moment, a delay is probably the most catastrophic thing that can happen to you in the course of a project. And we'll discuss that more in detail. But in the beginning, as soon as you can, the architect, and again, this is the prime designer, all designers, anybody, shall submit schedules for the performance of the services. And they'll include anticipated dates for the commencement of construction, substantial completion, and they include allowances for the owner's review, for the performance of owner's consultants, and for the approval of reviews and approvals by the code officials. Now, those last things are important because they are things that are consumed within your design schedule, but over which you just simply don't have control. But yet somehow when you schedule, you have to anticipate what it's going to take for people over whom you have no control to do something that you just have to hope gets done in that period of time, so that your design schedule can likewise be achieved within the time that you allocate for it. And so it's all a matter of anticipation, and if you do it well, and if things work out well, then all works out. If that doesn't happen or anything about them doesn't happen, then it becomes a problem. Now, we're going to develop the plan, and those of you who've been in San Francisco down to Buena Vista, it's about as far to the left in the West Coast as you can get. We're going to have our planning session there, and I note with a couple Irish coffees there, if you've never had the Irish coffee first thing in the morning, 2 will set you free, but 3 will really send you on your way with great vision. And so it's from there that we're going to make our plan. And what the plan is going to be is as we go across from San Francisco to New York, it's a very simple, obvious path to follow. It's I-80. So we're going to do Interstate 80, and that's going to be our path. And now what we've got to do is develop a schedule to achieve the path. And what we're going to do is we're going to decide as a part of our scheduling that we're going to have the design done by Salt Lake City. So we're going to go across Nevada and into Utah, and our design plan is to have all those things that need to be done to turn the design over to the contractor for bidding, negotiation, or whatever, to let the owner have their final design. That's all going to be done from San Francisco to Salt Lake City, and then we're going to let the contractors take over from there and have the rest of the distance of the country to finish the project, to construct the thing. All right, now, just as soon as we get the plan done and we knock down our third Irish coffee, we're going to get on the cable car and start the trip east. And we just get up on the top of the hill there, and we're looking back at Alcatraz, and then we see what has occurred, March Madness. Not the kind of March Madness that we all envision. Matter of fact, I think that is probably one of the things people miss the most. But we had a new kind of March Madness. And that new kind of March Madness just totally disrupted the lives of everybody and everything that was going on. And it became apparent that what was scheduled and what was going to be simply isn't going to happen the way it was planned and scheduled. And so we've got to do something about it, or we do nothing about it and we regret it mightily. So here's what our plan is impacted looks like now. So that simple I-80 across the country, we plop down that coronavirus in the middle of the trip, and you'll see it creates mayhem over there on the right side of the country, because we're going to run into all kinds, and the project is all kinds of problems and detours and delays and the like. And yet somehow we all are going to have to deal with it, because in the end the project still needs to get built. So what are we going to do? And here's the problem. The problem is that this contract here is the B-101, the standard architect's contract, says that once approved, the time limits established by the schedule shall not, except for reasonable cause, be exceeded by the architect or owner. With the owner's approval, the architect shall adjust the schedule if necessary as the project proceeds until the time of commencement of construction. So, in other words, we've got this time between San Francisco and Salt Lake City set aside for the design, and you got to get there when you're supposed to get there, except for reasonable cause. And you can see I put reasonable cause in red, in italics, in underline. We need to keep our eye on the reasonable cause that is going to keep you from getting to Salt Lake City or the design finished by the time you get there. And that's going to be a big focus. So keep an eye on reasonable cause for the reasons that you cannot do what you previously planned to do. All right. Now, what's the fuss over delay? I told you a little bit ago that I'm going to be concerned about delays. I will tell you it's very simple. Over the course of 40 years, I've had two people grow into adults, and when they were young, I bought their pencils and the books with errors and omissions. So you make mistakes. Everybody makes mistakes. And when you do, we can deal with them and we can resolve them. And generally speaking, as it relates to conceptually my view of the world, I can get books and pencils out of it. But it's when you have delays and we must come in and defend a delay claim, and when your carrier must pay the price for both defending and resolving a delay claim, the cost of that is exponentially greater than the errors and omissions, and that is, I say, how I paid my kids' tuitions. And so the difference between books and pencils and tuitions is the difference between errors and omissions and delays. And so make a mistake, figure it out, do something about it, and move on, but never, ever let it become a delay. And when something becomes a delay, it is a colossal problem. And the problem with the coronavirus is I am simply concerned it will have to cause delays. There's no way it cannot cause a delay. And so that's why it is so important that you keep it missile-locked in your vision. Will COVID-19 delay the design process? I have already announced that it would. Well, here's the plan, and we were going to walk leisurely across the country and conceptual plan. And the new reality of coronavirus is over here with this SEAL training, where you see the obstacles have just become monumental. And they're all obstacles that you were not planning on when you started the trip across the country. And the problem is that when you planned it, you did not build in for this kind of detour. True, you planned on regular things that you could foresee, and some you couldn't foresee but didn't deal with. What you are dealing with now has just totally flipped the plan and your ability to achieve it, and we just have to come to grips with that. Today we're going to focus on time and money. The three things that drive claims are time, money, and quality. Quality always, of course, is a factor, but today for coronavirus, we're going to let the quality take care of itself, but we're just going to be zeroed in on time and money, which, of course, is important to every participant in the project. The time involves the owner's deadline. They've got to get the project done by a day certain for a variety of reasons. And from that is a schedule, and there's two parts of it in concept, the design schedule and the construction schedule. Each one has to be achieved. If either one of them is off, and assuming that there was not so much fat built into either or both of them that they can just allow that to happen, then there's going to be a problem achieving the owner's deadline, and that's going to be a problem. The money, the owner's got a budget. I got so much money, I can't spend any more. Let's stay within it. You've got a design fee. You've got so much to do your services. Hopefully, you're getting fairly paid, but you're not getting more than you could, sufficient to consume and to take in a lot of extra work. The contractor said, "I'll do it for a price," but that price anticipated a regular schedule without hurdles. They could go from Salt Lake City to New York City. And then finally, the money that's involved is your liability exposure. That's what's of interest to me. It's what's of interest to Frank. And presumably it's what's of interest to you, and it certainly should be. And so we're going to focus on your liability exposure arising from the trip that we're going to be taking. Now, I will tell you, there is a relation between the economy and construction litigation. Having done this for 40 years, I did not live through the Great Depression, but I've lived through a lot of recessions, and I've lived through a lot of events. And what I've seen is as the economy goes down, the construction litigation goes up. And there's a reason for that. Because when the economy goes down, the money goes with it. And money is what drives ultimately a project. The owner has to get it built for a price. The contractor has to be paid a price to build it. And when the economy goes down and both of those numbers are hurt, those people start looking for money. I've got good news and bad news for you. When the times go sour economically, of the three-legged stool that's involved in a project, the only one who has secure money is you. You have an insurance policy. And they are really, when everybody else fails, look to the insurance carriers, they're still going to have the money. They planned ahead. And so people search for sources of money. And in construction litigation, you are the donkey that they will try to pin the tail on. And so you just sort of have to gear up, and it's not a very pleasant thought a message to deliver, but you have to gear up and plan against claims being asserted that may have no merit whatsoever, but the assertion of the claim can be both a nuisance to you and it can be a cost factor to you. And in the years 2008, 9, 10, and 11, while the rest of the world was suffering, the world of construction litigation was on fire for this very reason. People were searching for money, and you and your carrier had the money, so you became the target. And I say that not to give you undue heartburn or indigestion here in the midday, but to alert you to the need to be more in tune with good practice than ever before, because anything you do will be looked at with a magnifying glass and as they start searching for exposure. So anyway, with that, it's time to wake up and see what we're going to do more specifically. Our goal will be to provoke internal discussion within your firms and the development of discipline reactions. Now, over here to the left is the new way of internally discussing things. You get on Zoom, you get on, go to webinar, you get on meetings like that. And what you need to do is take advantage of the resources that you have in your office, and they are plentiful. You've got people who have, as I say, who have either grayer or lesser hair than you do. Go find that person and say, what do you think? What can we do? What should we do? Don't fight the battle alone. Discuss it internally and then see where you go from there. We'll be talking more about that as we go. And then you need to develop a disciplined reaction. It doesn't have to be quite as disciplined as this one here we see on the right, but you got to have a plan. So when something happens, you already know what you're going to do, or at least some variation of what you're going to do. Don't be caught flat-footed. And if we can accomplish that today, then our time together will have been worthwhile. All right, there are two basic phases. Now, I realize that is a gross oversimplification of the construction process, but there are two basic phases we're going to be talking about. That's going to be the design to the left and, of course, the construction to the right. What's interesting about these pictures is we already see a problem of social distancing gone astray. This is the way things used to be done. You'd grab somebody in the office and say, come to my board, come to my office, let's go to the conference room, let's put something up, let's touch it, feel it, look at it, point it out, snort it, breathe it, understand it, and then you moved on to the next step of resolution in the design process. That's not going to happen in the foreseeable future. I'm not real sure when it's going to happen, but it's not going to be in the foreseeable future. Same thing to the right. The construction is underway, And so you're out there, the contractor's out there, the subcontractors are out there, and what are they doing? They're getting a set of plans. They're violating every rule of social distancing, and they're discussing them the old-fashioned way. It's going to be different. And so the question is can it be as good now as it was then? And to assume that's the case, we have to assume that it's always been done the wrong way because there was a right way that wasn't being used. I must say, I think everybody's learning a lot from this current experience, but there's going to be a learning curve. Point being is you're going to lose some efficiency in the way you used to do things as things go forward. We'll be talking about those things. All right, now, the design phase we're going to take first. Again, in the left to right process of life that I live, that's the way we're going to do it. So you've designed it, and now you're ready to take the trip from San Francisco to Salt Lake City. You'll see the waypoints along the way. There's points A, B, C, D, E, and you're counting on things in some sequential order to occur. And you've got the car packed, and everybody's ready to go. It's just going to be so much fun to take this trip. And you've got all the things, what can go wrong, planned until March Madness hits, and then you say, wow, that just wasn't on the radar screen. What are we going to do? And so the question is when you were packing the car and getting the kids in and ready to go, did you anticipate all of this? This is kind of the car's version trip of coronavirus. Flat tires in the ditch, collisions, run out of gas, detours. There it is. And did you envision that? No. If you did, you didn't have a good schedule because none of this really was going to happen. And so you don't want to schedule in stuff that's not going to happen. So just by almost mathematics and logic, this kind of activity was not there, but it is now, and that's going to delay the project. So what's going to delay it, and what can you anticipate as you go forward, and then what are you going to do about it? I guess those are the questions. And I break down a few things that can be project design delays. Your team, and you need to critically assess them and get realistic about the impacts. If you just think, well, we can take care of this, but you really can't, it's not going to be good. First thing is your staffing and the inefficiency that results from a less effective collaboration of your group is simply going to slow things down. I had a good example of that just this afternoon. I'm at my home, out on the back porch, getting ready to do this webinar, and the power goes down. The internet goes down. And so fortunately, I happened an hour before, and I got in my car, and I'm a half hour from the office, and I got to the office, and fortunately I had somebody here who knew how to hook me up back up here. But the point is that I had planned on something that was dependent upon internet and power, and it all went away. That is a very isolated example, but the reality is the ability to grab people by the collar and make an announcement as you walk down the hall, everybody in the conference room in 5 minutes, we need to discuss this, simply isn't going to happen in the foreseeable future, and you're going to lose efficiency from that. It simply will be less efficient. Each of your consultants, if you have them, or if you're a consultant, everybody else involved on your team, the prime and other consultants, they're all having exactly the same problem. And so, if you all just happen to be having a good day, but you need to sync with somebody who is not having as good a day, whose power went down, whose internet went down, it's going to impact the back and forth of what they can do, what you can do, and then down at the bottom, I suggest, the collaborative effort of the team. And so the idea that you all will be able to accomplish in the same ease that you could have done before, it simply isn't going to be that way. Now, the owner is going to cause delays too. As you design this process, they have their new normal, same issues, same inefficiencies. You're not going to be able to get on the plane and go see them. You're not going to be able to get in the car and drive across and meet in their conference room. They're not going to be able to look at the carpet sample and say, that's what I want. They're not going to be able to look at the color charts and say, that's the color I want it to be. They're not going to be able to turn around. They're not going to be able to approve things in the same efficiency and speed that could have been and was anticipated when the schedule was put together. It's simply not going to happen. We've got delays by the owner's consultants. The owner may have a variety of consultants that you're not responsible for them, but you're responsible for your design that includes them, the schedule-wise. And when they don't perform, you can't perform. And when you can't perform, you don't make the Salt Lake City on time. Or when you get there, you don't have the design you need. And so, again, these are all people, and of course the owner's consultants, you simply don't have the kind of clout that you might have over your own consultants and so forth. And so these are going to be delays that are going to be working in conjunction with your own internal delays. Now we're going to have code review delays. You want to learn about America, Google code review municipalities, and you're going to find out there are more little towns you never imagined that each have their own set of rules. We're open here, we're not doing this, we're not accepting this, we're not doing that. You've got different states that have different allowances as to what construction is going forward, is not going forward, how it can go forward. You've got code officials who are trying to work remotely, but they don't have the electronics, they don't have the books, they don't have the remote capability. It really is a fascinating study of inefficiency as it relates to code reviews and the capacities right now. Georgia, where is one of the places I practice, of course, is the governor had an executive order a week or so into the coronavirus, and the executive order says, I have determined that all counties and municipalities in the state that regulate inspections and so forth may not be able to provide regulatory action or inspection within the time frames required, And then therefore what he did was he said, therefore, we're going to allow for private firms, architect engineering firms, to take on the role that is normally provided by the code officials as a matter of right. Now they have to be pre-qualified and they come under a set of rules, and this assumes that you are not a part of the design team. Matter of fact, you have to be totally disassociated from the project to do it, but essentially they deputize you to be the code officials. That's an official role, and when that happens, it may or may not speed up what you could have expected out of the executive, out of the officials. But there's going to be a learning curve, and there's going to be a lot of other things, and so nothing about it is going to be an efficient process. It's not going to happen within the same time that it did, and so you must factor in the fact that it simply isn't going to be reviewed in the same way that it was going to be reviewed before. You all have to design the budget, and I'm going to add another factor as this trip is taking place. And it varies from contract to contract, process to process. But essentially, there is a fundamental requirement that as you design, you keep the budget in mind, and you have to have some kind of cost estimating scheme that's going along with you on your trip, where you're adjusting the design up and down to be at or around or certainly under the budget. And the contract says that they understand that your evaluations of the work, the cost of the work, preliminary estimates, and the updated estimates represent the architect's judgment as a design professional, but the architect nor the owner has control over costs, labor, materials, equipment, the like, competitive bidding, and the like. And so there's a recognition that you're put to a task that in a great way and under normal circumstances you have a very challenging time achieving. But we are no longer in normal times. We have, as you see, their very uncertain future. And essentially what you're having to do is to look into a crystal ball and wonder, these products that I'm specifying, will they be available? Stones are not coming from Italy like they used to come. Fabrics are not coming from China like they used to come. Things that are being built in the United States are not being built in the same efficiency and speed that they were being built. They're not being delivered by trucks. They're not being, everything is a challenge, and that is all going to impact the price because supply and demand will continue to prevail no matter what coronavirus does. And if they're not there, then there has to be a change. There has to be a pricing adjustment, and then there's going to be time involved. Because the efficiency of labor and the ability to achieve work, particularly when it's all jumbled up with product supplies, shortages and the like, and changes, is just going to be different. And so there's going to be more general conditions either on the back end, or there's going to be more general conditions and work required to accelerate on the front end to make it happen. And so you're sitting there looking into a crystal ball while you're trying to get to Salt Lake City, and you're trying to achieve this. It's going to be a time-consuming task, and it's going to be a potentially a challenging task. And, of course, the contract then provides in some format, and it depends, that when you don't achieve it, you got to go back to the drawing board. And so the sense is that when you get to Salt Lake City, if you get there on time or wherever you get out west with the final design, when you then learn that when it's tested by the market conditions, your design cost more than the owner has in the budget, they have a couple options. They can change a lot of stuff, but one of the things they can do is tell you to go back to the drawing board. And if you are met by things that you could not have reasonably anticipated, under contract, they pay you. If, though, you cannot show those things and you just haven't gotten the design of meets the budget, then you have to design it at your ticket. Well, two things are taking place. You're spending time one way or the other that you may or may not get paid for, but also the project is being delayed. And you might remember we got to get to New York City on time, and if you're spending extra time committed to a redesign, then the project is going to be delayed, and it's not going to be much of a challenge to a plaintiff's lawyer to show, well, right here was a good chunk of it, because, we spent a lot of the time on this trip while the architect did after the fact what it should have done before the fact, which was get the thing under budget, and it'll all be your fault. Trust me, it'll all be your fault. And you just need to put that on the radar screen and say, we've got to anticipate this and deal with it as we go, not after we get to Salt Lake City. So it's all that's going to impact your time and money. I suggest to you that everything I just mentioned is really cumulative, and I call it exponential in effect. So every one of the things I mentioned on its own could cause a delay. But when you put them all together, and you don't know which is going to come first and what's going to trump the other and what's going to compound all it, it just simply will look like this if you're not in anticipatory control of what's going on. And even then, it's going to be a challenge. Could be a challenge. So what must you do in reaction to all of that? Not what can you should do, not what should you do, what must you do? You got to do what this guy here has done for the last few weeks. You have to anticipate what's going to happen. And you have to communicate by and with everyone you can possibly communicate with to see how you're going to deal with it. Not you as in just you as in your design team, you as in the design and construction team, you as in the design construction owner team, everybody. How are we going to deal with this? And so the communication is going to be broader than it's ever been before. And then finally, you're going to have to document. It's not enough to come up with a brilliant conclusion to a challenging task. You have to document it because I can assure you 6 years from now, when the litigation is underway, what you all agreed to verbally and had everyone smiling happily with, and you proceeded in the way everyone said was okay, if it's not written down, some expert 6 years down the road is going to say it didn't happen that way. And the recollections of your friends in the contractor industry and in the owner's industry is not going to be nearly as good as you think it's going to be. And generally challenged with economic crisis, recollections either fail or they become better in the sense that they're more creative. And so the point is that you have to document. Now, I give this picture here. On the left is documentation before coronavirus. That's what it's going to look like. And I'm happy to tell you I've dealt with enough cases to know it never looks like that for a project of any meaning. But just conceptually, that's what it's going to look like, comparatively speaking, to what it now is going to have to look like, which is that library on the right. My wife has a friend who does flowers, and her motto is too much is never enough. And as it relates to documentation, too much will never be enough in the coronavirus world in which we are now living and upon which we are embarking. Now, what I want you to do is remember that term reasonable cause, because what you're going to have to do is when you get to Salt Lake City or when you get to Denver or when you get to St. Louis or wherever it is you're going to get to, where you're called upon the carpet to explain how come things were late, you're going to have good evidence of the variety of sources of reasonable cause that kept you from meeting the challenge of the schedule that was laid out. And so, as I say, Your documentation needs to make War and Peace look like a short story. And it's got to be good. It's got to include everything. And the time you spend now keeping up with the variety of factors that were beyond your control as a result of coronavirus that have delayed your design process and relieve you from the responsibility for the delay because there was nothing you can do about it, the better off you're going to be. So just make reasonable calls, documentation, your companion sitting shotgun in your seat as you drive across the country on your way east. So that is, I think, let's see, that is going to be a thought on the design phase. And really, everybody's thinking in terms of the construction phase is the problem. I think on a real world pain in the neck problem kind of thing, it's going to be in construction. But the liability exposure, I think, is greater in the design phase because that is the phase that is most easily isolatably attributable to you. And you just need to do what you can do to make sure you cannot be blamed for an improper, unreasonable, or wrongful delay. Construction phase services. So the contractor is supposed to plan and has planned on picking up the plans in Salt Lake City and doing their work as they go across over there to New York. And obviously, they're counting on the entire amount of time. So if when they show up at Salt Lake City, you're either not there or your plans aren't ready, that's going to be an immediate problem because you're eating into their time, and that's going to be a problem. But we're going to talk about what your activities are during the construction phase that might be of interest to you. And, of course, what you do during that is you provide contract administration. You don't provide construction administration. Everybody says CA. It's just unfortunately coincidental that contract and construction both start with C's. The C in CA is contract administration. And so first thing, you got to have the contract. It's just really surprising, if not shocking, how many times we've got CA cases and we say, well, give us the contractor's contract. And they say, well, we don't have it. And, you know, I mean, I don't like to make people feel bad, but, you know, kind of you got to have something to administer it. So, you know, hopefully, presumably, you've got the contract. And so your job here is not to administer the construction, but it's to herd the cats as you go across the country. And they're going to talk about a variety of things we could. We're going to talk about three things today. We're going to talk about your site visits. We're going to talk about change orders, claims, and other decisions. And we're going to talk about certifications. We could take every other topic that is involved in CA and spend all afternoon on it. I've got good news for you. We're not going to do that. They all just have to be ratcheted down. But these are the three big topics of things we're going to talk about, and there's some issues within it that we'll pick off as we go. All right, so site visits. Here we see, again, the traditional way of doing a site visit where you show up, put your hard hat on, you get the plans out, you get up close to people, and you look and you smile and you get things done. And as you know, for a variety of reasons, that situation simply isn't in the cards at the moment, and no one knows when that is going to change. And so what is your standard requirement? Let's start there. And, of course, my point here is I say standard requirement because your requirements differ from job to job to job, contract, project. So don't take this as the Bible as to what it is. Know what it is, but this is the standard one. And it says that the architect will visit the site. This is from the A201 at intervals appropriate or as agreed. And that on the basis of the site visits, and I've underlined that. They didn't do that. I did. The architect will keep the owner reasonably informed about three things. One, known deviations from the contract documents. Two, known deviations from the most recent construction schedule submitted by the contractor. And three, defects and deficiencies observed in the work. Well, this is not really going to be a lecture on how you keep up with those three things and report them. The lecture here and the thought here is, what do you do physically to accomplish the need to visit the site, and what does visit the site mean? The big question is, are there alternative ways to skin the cat? Can I do my site visits without visiting the site? And really, when you just sort of say it in a logical form, the first hurdle becomes, well, is it really a site visit if you don't go there? And we've internally thought about this, and it may be, of course, you all are practicing architect engineering all across the country, and each state is going to have its own rules. Your contract is going to have their own rules. And so what I'm going to do today is talk in general concepts. I'm not going to be talking about in anybody's particular rules. But, you know, the question is do I think that you can do a site visit without visiting the site and still achieve the obligation of your contract? I frankly am concerned that that will not be the ultimate conclusion of the courts. One thing about law is none of us really know what it's going to be until someone has tested it in an appellate case and the courts come out and say, here's what we think it is under these circumstances. Well, obviously, none of that has happened in the time that has passed so fast and quickly with coronavirus. So we have to sort of do our own vision into a crystal ball. And I'm concerned that if a contract says you got to visit a site, you have to visit the site, or, and here's the big or, you have to revise the contract, revise the obligation, come up with a different way of doing it that is contractually acceptable. And so the big question is can we have the contractor take pictures? And then can we have us look at what they do on the computer and ask questions and the like? And will that equal a site visit? That's the question. And just in a pure contractual version of things, I'm concerned that it will not. And so does that mean all of you have to get on the plane and go there? No, that's not what that means at all. And that's what we're going to be talking about. What are your alternatives? All right. I put this 10-point thing up here because, and I say, what might you consider doing, Ray, alternative site visits? And I focus, might you consider, this is not your checklist for what you need to do. You need to check your own circumstance in your own place, and you need to talk with your own lawyer about what you're going to do. But these are thoughts as an outline I think are worth considering. The first thing you need to do is determine and understand the design team's contract requirements. What I told you was a requirement, and that may probably be the base requirement that you have. Don't count on it. Contracts change. Go to your contract, read your contract, and see what is required of me and of my consultants or my prime as it relates to site visits. You need to assess the project factors. If the project is on the other side of the country as distinguished from on the other side of the street, that would be a factor. Is it a project that just simply requires you down in the dirt or down wherever you need to be and looking at things head on? Is it going to require that? Have you got a problem contractor that you can't trust to do something you can't count on, or you know is not going to do it right? Have you got an owner that is overly insistent? Have you got one that's reasonable? What are all the factors that are going to go into how you're going to, as I say, skin the cat? Then you have to, with that information, you have to determine your internal desires and your plan for achieving the required results. The required results is important because in the end, coronavirus does not relieve you of doing the things you have to do. What you've got to do is figure out how are we going to go about achieving those desired results, and to do that, sit down internally and talk about it, and then discuss and coordinate those same thoughts and plans with the design team members. I mean, if you're an architect and you've got a mechanical engineer who has a different view of things, you all have to talk about it together. And so everybody's got to come up with a team understanding of what you hope to do as an alternative to going to the site. Then the next step I suggest is take it to the owner and you communicate and you say, owner. And the good news about coronavirus, most people have heard that it's taking place. And so they're not going to be surprised when you tell them that you have concerns about travel, that you'd like to figure out an alternative way of doing things. They shouldn't be surprised. And so what owner can we do that will allow us to achieve our required results to your satisfaction and to the satisfaction of the project? And hopefully you'll have an owner who will allow some consideration of alternatives and say, well, the owner probably going to say, well, you know, if you can work out something with the contractor that is satisfactory to you and is satisfactory to them, and it's not outrageously unsatisfactory to me, then I think we can work with that. Hopefully that's the next step. And so then you go to the contractor and you try to find a mutually agreeable plan of action. Now, it's got to be mutually agreeable, because you see, if you say, we want you to go around, take pictures of this, that, and that, and create a full-fledged movie every 2 weeks for us to view, they might say, well, we're having enough trouble building this thing without being your movie producer. So we can't do that. We'll take a couple pictures and send them to you, and if that's not satisfactory, then you just need to get on out here and look at it for yourself. You got to find something that works with them, and then you got to find something that works with you, because in the end, you're going to have those obligations. You're going to have to be signing certificates for certificates for substantial completion. You're going to have to be signing pay applications, certificates, and so forth. You've got to be doing some things, and you have to be satisfied with your professional activities that you have the information necessary to fulfill your requirements in the end, and it's all got to work together. And so whatever level of rolling up your sleeves it's going to take, in communication with the contractor, you just have to come up with a mutually agreeable plan. And then once you do that, you take it back to the owner, and you document with everybody what that plan is going to be. Don't just have it in mind and in everybody's agreement. Document it. And it's not a bad thing to tell the story. Coronavirus came by. We weren't counting on it. It's made this difficult, and we've all agreed that we can do this, and here's how we're going to do it. And then number 8, document the agreement with the owner that the alternative plan is contractually acceptable. In other words, you've got a contract that says you will visit the site. We've now all agreed you really don't have to do it. Somebody's going to send you some pictures, and you're going to look at them. And that's okay with everybody. What you need to do is to confirm in writing with the owner that will be in satisfactory in lieu of the contractual requirement for site visits. So in other words, we're going to change the contract to meet the agreement that you've made. Do you need a formal amendment to the contract? It wouldn't hurt, but I'm not about to tell you that you need to be bogging the owner down with an amendment like that. I think under these circumstances, a good email that lays it out and asks for a confirmation by them that this will be an acceptable way of doing it, and it will be considered satisfactory to the owner from a contractual standpoint. If you got that, then I would think you're going to be golden. But by all means, please involve your own lawyer in that, so they're not going to be saying, you did what? You heard what? Or what kind of webinar? When? By who? Don't let that happen. Make sure everybody's happy with it. Then what I want you to do is to communicate and document it with code officials and with lenders. They're two different animals. A code official is expecting something out of you. And different states and different regions have different requirements. If you're not going to be there, what you need to do to tell the code official, well, the reality is if they start out the project thinking you're going to be there, and it turns out you ain't going to be there, no matter how much everybody else agrees with it, you may have a requirement to tell the code official. Hopefully, it's just a matter of notifying them and confirming it with them. I'm not sure that you really need their agreement. Anything you can do to make it appear that you got it is good, but don't leave them out of the mix. Lenders, all of those lenders' documents that you got in the beginning that they don't have any right to have you sign, but you have to sign them because your owner can't get money. If they don't get money, the project doesn't go forward, so the lenders all impose on you to sign these oppressive documents. Hopefully you got somebody that waters them down. But in the end, one of the things may be your agreement that you will not fundamentally change your agreement without their agreement or without their confirmation or something. And so what you don't want to do is change something fundamental like a site visit definition or requirement and disregard an agreement you may have with a lender, whether you like it or not or whatever. So go back and dust off those documents, read them. And don't let them get in your way, but don't disregard them if you have some obligations. So clean that up too. And then finally, as I say, repeat any and all of those if and as any of the things change as you go. So it's a moving machine. Make sure the documents move with it. Now, everything's worked out just well because I lined it up like this, and everybody said yes. What if somebody says no along the way? if somebody says no along the way and you're not able to do the alternative that you want to do, and no amount of negotiation seems ready to do that, it's time, I think, to report that to your broker and to your carrier as a pre-claims circumstance. And you've got good pre-claims coverage that involves the carrier and the lawyer. And I will tell you that if under this situation, if someone brings to me a pre-claim situation, I would like to think that we would have some ability to talk some reason into whoever the obstinate person is that's not allowing it. And then if we can't, then we will all make a reasoned decision as to how we're going to handle it. And I don't know how we're going to handle it because I don't know the situation. But I think in the end, rather than just disregard the contract language for site visits, and rather than just go ahead and do something against your will by folding and going, let's all decide what your options at that point would be, and then we'll make a decision. But it needs to be a reasoned decision. So there's a lot that goes into this idea of, do you get on the plane or not? Do you go see the thing? And look at this kind of outline and do it from project to project. And every project is going to be different. None of these situations are going to happen the same. It's all going to break down in different ways. And so consider project for project. It's going to be a lot of effort, but it will serve you well if you do it. All right, now, what if you want to go or you do go and your access is impeded? You got the contractor says, we're not letting anybody on site for anything more than this amount of time or this amount, or we're not going to let you do this, not going to let you do that. So you're impeded. What do you do then? And so we'll talk a second or two about that. I call it the standard site management rule. I'm not real sure there is such a thing, Ray Safety, but just looking at the A201, it notes importantly that the contractor shall be responsible for initiating, maintaining, and supervising all safety precautions and programs in connection with the performance of the contract. Another section says, in an emergency affecting safety of persons or property, the contractor shall act at the contractor's discretion to prevent threatened damage, injury, or loss. Now, I really don't know whether the current situation rises to the type of an emergency that's being sought there, but what these two provisions do is they solidify the fact that the contractor is responsible for the management of the site and for the safety of everybody on it. That is their job. It is not your job. And so with that in mind, the question is what might you consider doing if you encounter a problem with access? Again, these are might considers, these are Stair said do it, therefore do it. But think about these things. First of all, determine and understand the project's rules for governance of the site. In other words, I gave you one that's a standard. There are others. Come to understand what are the rules as established by contract, and just know them. And do not interfere with the contractor's control or running of the site. If you get on there and say, I'm going to do it this way, I don't care about you, I'm going to do it that way, you need to be letting me do this, you need to be letting me do that. This is not the time to demand. This is the time to let them control their site, and you're going to have to react and deal with it. Having said that, the point is, do not let them impede your required necessary site visits or your related CA activities. Remember, C stands for contract. So we're not going to let them keep us from doing what we're going to do, but we're certainly going to let them be in control of their site, and now we're going to deal with it. If you can't deal with it in a fairly straightforward, simple way, what you need to do is communicate with the contractor in search of a resolution. And hopefully you'll find one. Communicate with the owner if you are continuing to have problems. Say, owner, I've got a contractual duty to be on the site. The contractor says it's unsafe for me to be there, or I can't be there, or I can't do this, or I can't do that. That's a problem. We need to address it. You need to address it, or we need to address it. You need to communicate internally if there become continuing issues. And so in other words, if those first two things don't get you satisfaction, again, take it up internally and then document whatever resolution you get that allows you to go or keeps you from going. And then document delays and problems resulting from all these issues. And as I say, elevate remaining residual or continuing problems. Who do you elevate it to? you elevate to those people in your firm who, as I say, are less blessed with hair than you, or it is grayer than yours, or they're at the top of the firm, however they got there. Take it to them. Take it to your carrier. Take it to your lawyer. Take it to someplace. Just don't leave it behind and be abused by not being able to go to the site and do what you need to do. You got to do it, but the contractor has to run the site. All right, now, what do you do if you do go and you observe unsafe practices? So now we're making the site visit, or we're doing it virtually, and we're seeing this very same thing. We've got three situations here. We got first problem, those folks are not exercising social distancing, and we've got now rules that say you got to do it. That is an unsafe practice. Do you say something about that? The second one, you'll see those three guys are still failing to exercise social distancing, plus those do not appear to be hard hats on the heads of two of them, and I guess that is just the hair on the third one. We don't have hard hats. The third situation, we have the combination of social distancing gone wrong. We've got no hard hats, and then I have indicated holy cow. There are a lot of other ways to describe that, but holy cow will be it because it's going to be part of a rule I'm going to tell you about. So we got three situations here. You've gone and you see these. What do you do and what do you say? The standard rule for site safety is the architect will not have control over the charge of or responsibility for construction means, methods, and so forth, or procedures, or for safety precautions in connection with the work, since these are solely the contractor's rights and responsibilities under the contract. I will be surprised if your set of rules says anything greatly different than that, but whatever your rules say, you need to know what they are, and don't assume the A201 is going to be the Bible in every instance. It'll probably be the scripture for most, but go find out exactly what it is, which brings us to what might you consider doing with the observations of unsafe work practices. First thing you need to do is determine and understand the project rules and the state law concerning site safety. State laws differ. If you see something dangerous, must you say something? Should you say something? Do you not have to say something? And you're not going to become lawyers on it, so don't get bogged down in state law. But fundamentally, you need to know what are the rules applicable to your obligation as it relates to observations of unsafe conditions. Generally speaking, I think you're going to find it is that you do not interfere with the contractor's control or the running of site safety or means or methods. So do not generally, number three, note site safety concerns except in situations of imminent and potentially catastrophic danger. The first situation with the social distancing, you may be repulsed by that from a personal standpoint, societal standpoint, but it's not a danger item that should cause you to interfere with the contractor's site safety. The problem is when you start, you then get on the slippery slope that goes forever and you can't get off. If you don't start and somebody gets hurt, you can always say, well, it wasn't my job and that's not my duty. If you start and you don't do it on a time that matters, they will always say, well, it wasn't your job, but you made it your job. And so you cannot make it your job by undertaking a duty like that, so don't do it. The same is true with the hard hats. I mean, the Three Stooges, I don't think they're affected by the fact that they don't have hard hats anyway, but it's not your job to be the OSHA director, and when the wires are loose and the hard hats aren't there, those are not responsibilities for you to concern yourself with, and so you do yourself a favor to not get involved in it. Having said that, where there is a situation of imminent and potentially catastrophic danger, I apply my holy cow rule. And my holy cow rule is you look at a situation, and instead of just shaking your head from left to right, saying, my God, why don't those people wear hard hats? Stooges. What's wrong there? That's not a holy cow rule. But when you look at something like those guys sitting out on that beam, and your reaction when you see it is your eyes get big and you go, holy cow. When that happens, then you do something. And you violate Stair's rule of don't do anything, you do something. And what do? You communicate forcefully, if and as appropriate, with the person in danger. You don't want to scare those guys off the beam, but you got to say, guys, could you kind of, okay, everybody be cool. You need to get off that beam. But and obviously that was not going to happen. But if you see somebody in imminent danger, say something as the circumstances require. Then communicate ASAP with the contractor superintendent. He's the one, she's the one supposed to be responsible. You're not. And so you go and say, look, I don't know last time you've been to the 14th floor, but you got no railing up there, and you got people working within 2 feet of no railing on 14 floors up. You need to go do something about that. Now, it's important that you not tell them what to do. You don't tell them how to do it. You just tell them they need to do it. Because once you start telling them what to do and how to do it, then when it's not enough, then you'll get into another line of danger. So just tell them, folks, you got a problem. You need to deal with it. And then document it with the owner and the contractor and with anybody else who's appropriate to make sure the record is made that what you did and what you didn't do. And that is the exception to the rules, the holy cow rule. Now, is that good legal advice? I don't know. Ask your lawyer. I don't know. But I would rather you do something that's personally responsible. Instead of calling me up at 11:30 at night and say, Ken, I got good news for you. I saw a situation, but I took your advice. I didn't say anything about it. The guy fell off. I hate that, but I'm not responsible because I stayed out of it. I don't want either of us to have that story. We will deal with your responsibility, but only do it when it is imminently dangerous. Now, and then as I say, number 6, elevate any remaining residual or continuing problems. If you get out there and it is a imminently dangerous situation that they simply won't resolve it, don't say, well, gosh, I wish they'd fix that. Take it up, take it out, do something with it. But generally speaking, if you're out there and all you're seeing is social distancing and other rules as it relate to coronavirus and so forth, do not make that a subject of your CA concerns. Okay, now, let's see. I just lost. What did I just lose? Okay, connect, go to webinar. Oh, Lord, let's see. Oh. Somebody out there. Okay, good. I'm back. Okay. I didn't know what Zoom was 3 or 4 weeks ago, but here I am sitting here doing this. Okay, let's see. Okay, can somebody give me the machine back? There you go. Now, the next question is what if you go and you're going and the owner or the code official ask you to perform some of their inspection services because they can't make it, they don't have the personnel, whatever they can't do, and they essentially give you the keys to perform their services, and you become Chuck, the building inspector, in addition to the architect or the engineer. What do you do if that occurs? And I understand that is occurring simply because of the absence of code inspectors, the overwhelming, the remote, whatever it is that keeps them from doing their job that would be a normal code inspection. They say, here, architect, here, engineer, you do it. Should you do that? Let's see. All right, let's see. Okay, let's see. Can somebody change the screen for me? I've lost that ability. Okay. The big difference between you and Chuck is that when Chuck does it, he gets out of jail free. He has immunity by law. So a code inspector can go, they can look, they can see, they can miss the code violation, and then 3 months, 6 months later, when it becomes apparent, they can say, well, guys, we're going to have to stop work, and y'all going to have to fix that code issue. And, people are going to say, well, look, Chuck, I mean, you saw it and you agreed to it. He said, well, I guess I missed it. And Chuck gets away with that. If you are deputized informally or formally to be Chuck, and you go out there and you make the same inspection and you make the same oversight that Chuck made, when that becomes a problem and the project is delayed, then you go to jail. Put another way, you get sued for the delay, and you don't have any immunity like Chuck does. That is a huge problem. Okay. The Georgia law exemplifies this. I told you how the Georgia governor said because of the shortage of people, we can appoint, and these are officially appointed people who are unrelated to the project. If you are someone who is casually given the keys informally, and you do it, the situation is going to be even worse for you. But this is actually part of the law that governs that situation in Georgia. And it says after the building has been constructed under plans reviewed and inspections made by the AE providing the building code inspections. If the official inspector determines that the building construction or plans do not comply with regulatory requirements, the official may deny the permit or request for a certificate of occupancy or completion, or as appropriate may issue a stop work order. So we've got a project that's going along. You have been duly deputized to be the code official. As that role, you've said, okay, we can keep going. The real code official gets to come in whenever they want to. They don't have to. That's the real bad thing. They don't have to, but they can. And they can second guess you, and they can say, shut it down. And they get to just shut it down. And when it gets shut down, let me tell you what. Heads will start rolling, and the first head that's going to roll is that person who, acting in the role of the code official, either as the reviewer of the plans or as the inspector of the work who missed it, quote, end quote, that person is going to be looked at as the cause of delay, cause of the extra expense. And if you don't have immunity for that, I can tell you that will be a day you will regret. What does that leave a person who is providing private performance of public function? What kind of ammunition does it leave them with? Not much. Barney has got to take on the entire British Army with that single bullet under these circumstances, and he's not going to do well. He's not going to do well. It may be the British are not good shots, but sooner or later, Barney's going to run out of ammunition, and it's just not going to be pretty. That's what you want to try to avoid. So what might you consider doing if the request to perform some or all of the code inspection services? Decline as tactfully as you can. If that does not work, continue to decline with decreasing tactfulness. You need to explain the differences in your role and responsibilities versus the roles and responsibilities of the code official. They are different. They look for things and have responsibilities that you don't look for and you don't have. If you assume their responsibilities in addition to yours, you really magnify your exposure out there. You need to talk about there would be a resulting increase in scope. There would be an expansion of uncompensated and unprotected professional liability exposure, and every other reason you can think of, that's the time to take it out of the bag and throw it onto the table. And if that still does not work, then request some of that pre-claim assistance and discuss it with your carrier and your counsel. And hopefully, and again, you're saying, well, you sure are concerned about this. The point number 5 makes my final point. If none of that works, transfer all of your personal assets into a name of a dear and trusted loved one. Frank and I were laughing about this before. He's saying, with the divorce rate being such as it is that a good idea? I'm not an estate planner, but as a lawyer, I can tell you what you don't want to be is someone who is professionally and personally responsible for the problems that can result from taking on a code official's duties in a unqualified, undefined, casual way, or even in the official way, without recognizing the potential exposure that you have. So I would really, really stay away from that and talk to your lawyer and talk to your carrier before you get involved in that. All right, now we're going to talk about change orders, CCDs, claims, and other decisions. And again, the point is that as you make this trip across the country, there's a limited amount of time and there's a limited amount of money. And the time has been eaten up and will be chewed away on by a coronavirus that we didn't expect and its ramifications. The money will be a problem because it's going to have to be adjusted up and downward to deal with the changing of the circumstances. And so there you are caught in the middle. It's not your money, and in a sense, it's really not your time. It's more the contractor. But you somehow have to be in the middle of their arguments in a variety of situations. Let's talk about some of them. Because really what you've got with time and with delays, you either have to extend the schedule or you have to accelerate the work, and each of those has a monetary element to it. And what you then have to do is you have to either increase the budget or you got to decrease the cost. And by decreasing the cost, you got to design the thing downward so it can be built for the money that's left to do it after all the other ramifications have occurred. So it really is a critical thing to be dealing with it. Now, your role in claims analysis, so you're stuck in the middle of all of this, and under the 8201, you will interpret and decide issues upon written request. Make sure you get a written request. Don't be just casually out there in the middle of the ring giving everybody your casual thoughts about opinions and things. There is a process where they put claims to you. Make sure you understand the claims process and make sure they do it right. Respond timely. Endeavor to secure the faithful performance. Critically, you must not show partiality to either. The contract says you will not be liable for results or interpretations rendered in good faith, but it goes back to do not show impartiality to either. The problem is most times the owner brings you to the dance, and the owner is the one that's going to take you out on the next date. And so the owner is the one who has your ear. And the reality is, though, is the contractor is not the cause of coronavirus. The owner's not the cause of coronavirus. But between the two of them, who has to bear the financial burden of the coronavirus? Frankly, it's the owner, because they were the ones who were going to receive the reward for the project. They're the ones who going in must accept the risk. Now, this was not a risk they had in mind, but risks are risks, and this is theirs. And if it costs more money, they're simply going to have to pay the contractor more money. They're going to have to pay you more money. They are not going to want to pay either you or the contract more money. And so when you have an opportunity to be in the middle of the argument between them and the contractor, they're going to be whispering in your ear. It doesn't look like either one of those fighters was whispering in the ref's ear at the time, but they're going to be saying, remember, who brought you here and who your friend is and who your friend's been in the past, who's going to be in the future. You must not show partiality. And it's going to be difficult, but you got to get your backbone ready for it. All right, now, let's see what we got. Next slide, please. Okay. The contractor on the A201 gets requests more time, and these are the circumstances, they say in the A201, where there's an unusual delay in delivery or other causes beyond the contractor's control. Well, certainly coronavirus and the circumstances surrounding it seem like they fit somewhere in there. And then there's the catch-all, or by other causes that the contractor asserts and the architect determines justify delay. Then in that event, the contract time shall be extended for such time as the architect may determine. So basically, you got a lot of clout there, but you got to do it impartially and fairly. And the reality is the contractor probably is entitled to some money. Now, make sure they put the claim to you in the proper form. So you're going to have to say, well, how are they supposed to do it? Make sure they do it, because you're not in the business of handing out money where it's not asked for properly. So do that. And again, let that be your ruling, if you will. And your decisions are always subject to being overruled by subsequent litigation or claim process. And so, again, just understand, you have to recognize that these circumstances under which we're all operating on are probably such that the owner simply is going to have to understand that more time is going to be involved or some equivalent resolution of that issue. You've got value engineering and substitution. Of course, that's always the bane of every project where you design a mechanical system that is absolutely wonderful, and they say, well, we can do this a little cheaper way. Anybody got some ice and a good fan? And so you get beaten down. And so in this situation, we're going to have things where not the mechanical system like that or the ice is going to be the issue, but there's just going to be a lot of things where they're going to have to be a lot of substitutions for a lot of reasons. Products simply aren't available as specified. They're not going to be delivered on time. We're going to have to substitute something. And the process of substitution is a time-consuming and a potentially liability-giving process. And I want to just kind of alert you to it. When you get requests for change for time or money, what are some of the things you might consider? And again, I say in this situation, number one, prepare for a potential onslaught of issues and disputes, rate time and money, because when you think about it, there's just so much opportunity for everyone to complain about so many different things as a result of the circumstances in which we've all been put. And it all comes down to time and money. And if you're in the middle of it, just get ready because it's going to be a challenge to your time and your judgment. Communicate internally rather than handling. Get inside the firm and say, here it comes, here it is, it's here. What are we going to do? You need to insist that everybody in the process do their parts in providing information backup. You should not be the only one working. If the contractor's got to provide backup, make them provide backup. If the owner's got to do or say something, make them provide it. Make everybody do their part. Communicate with everybody and document all the challenges, costs, and delays that you encounter, and they will be great. Number 5, require change orders for all substitutions so that the final contract documents will reflect what was substituted and built. The A201 9.4.2 says specifically that all substitutions must be reflected in a change order executed by the parties. You can't do it in emails. You can't do it in submittal reviews. It has to be if it's a substitution, even if of equivalent value. If you specify product A and they put in product B, and they didn't have the alternative by the contract documents, you need to change the contract documents to reflect that product B was ultimately agreed to. Because in the end, somebody needs to be able to take the contract documents as revised by change orders and the like, and go look at the project and tell you what it's going to look like when they get there, because it ought to look just like the contract documents say, and vice versa. What happens in a lot of claims is it will 5 years, 10 years down the road, somebody be looking at the contract documents, somebody looking at the project, and they don't match. And everybody says, oh, yeah, but we agreed back then. Well, let me tell you what, folks, if it's not a change order, it didn't happen, and they don't meet the contract documents. So it's important that substitutions, no matter how laborious that gets to be, have to be reflected in a change order. Address impact on time in all change orders. Change orders say everybody's focused on the money as it goes up and down, or the definition of the work as it goes up and down. There's that thing about, and its impact, the time is unchanged, it's changed as follows. Always address the time. Even if to address that you're going to address it later, don't ignore the time, because owners always think when they resolve it as to the money, they think they resolved it as to the time. And if you let people nonchalantly include by exclusion delay claims down to the future for the change order they always thought they bought, you're not going to have a friend in the contractor. So keep your eye on the time. Make sure whatever's happening to the time is reflected in the change order. So again, the document is a living, moving document that is reflecting what everybody knows is going on time and money-wise. Again, resist undue and inappropriate pressures. I've talked about that. It's the same thing here. Seek ad services as appropriate. I mean, you're not supposed to be doing all of this for free. And if you're spending all your time being everybody else's nursemaid in a way that was unanticipated and beyond what is normally expected, there are ad services appropriate. We'll talk about that in a few minutes as we're going out the door. And then finally, number 9, increase your calcium intake to strengthen your backbone for the remainder of the trip. This could be a challenge because everybody's going to be challenged with money, and you're going to be in the middle of it, and you need to be in as much control of the circumstance as you can. And it's going to be tough, but get ready for it. You can do that. All right, now let's see what else we got coming up here. Certifications. You see there, justice is blind, and I'm sure that all of you have some other humor about justice. And my question is if justice is blind, can you also be blind in your certifications? The answer to that, I must tell you, is no. Certificates for payment. The A201 says the issuance of pay certificate will constitute a representation by the architect based on the architect's evaluation of the work and the data and so forth, that the work is done well and so forth. And so when I first read that contractually, I thought, well, that's cool. Evaluation of the work doesn't really say site visit. But then Tawny, my partner in Atlanta, who is patiently listening to all of this, took me derivation of evolution, and it really starts with site visit. So site visit is built into that, and that's reflected in the certificate that you actually sign. Everybody signs this pay app certificate, and it says that the architect, based on on-site observations, and the data says that such and such and such and such. So you say the certificate is based on on-site observations. Well, you remember a little while ago, we fought hard, and we got an alternative way. The owner has agreed to it. The lender's not unhappy about it. The code official's okay with it. and we didn't do an on-site observation. And yet you are certifying here that based on that kind of observation, something is good. Well, if you didn't do it, don't say it. And the fact that the certificate as pre-printed by the AIA says you were on-site, if you weren't, don't sign it. Take your pen out, scratch out on-site observation, say upon observations as agreed to by the party, say anything you want to, just don't say something that's untrue. Hugely, hugely important to make a certificate match the facts, not let it misstate the facts because it's stated so in a form certificate. Substantial completion, it says the architect upon receipt of the punch list will make an inspection to determine. Well, again, inspection I think doesn't mean getting stuff over the email, sitting up late at night chewing popcorn and looking at it. I think it means getting out there and looking at it. And then it says prepare a certificate based on that. And so the certificate of substantial completion does say that the work has been reviewed and found to be okay. Still, reviewed is a little softer word, and I think maybe that certificate doesn't need to be necessarily revised, but keep an eye on it because you want to make sure that when you sign one of those things, you are stating the truth. And then upon final completion, same thing back to visits. Upon receipt of the notice that the works are ready to go final, the architect will promptly make an inspection and promptly issue a final certificate stating that on the basis of on-site visits and inspections. So again, contractually, you see, they're expecting you to be there and doing it. And so what you need to do is you need to adjust the certificate to meet the facts. And so, you know, if what happened is different than what the contract said was going to happen, you need to revise the contract to make sure it reflects what you did. If a certificate says something happened when by agreement it didn't happen, make sure the certificate gets whittled down and said right. Because the last thing you do is 6 years down the road, have somebody saying, well, you certified on a site visit, you didn't do site visit. Well, yeah, blah, 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 blah. Bad way to have the conversation when it can be resolved if you say, well, we all agreed, and actually the certificate reflects that. All right, now, certificate of termination of the contractor, you know, with times being tough as they are, one way out for the contract for the owner is to find a reason to terminate the contractor. And so they can do it for two reasons. They can do it for cause or they can do it for their convenience. The problem is their convenience costs them money. And so if they just say, well, I'm just deciding this is not worth anything and I'm losing money, we're going to call it off, they still have to pay the contractor for not doing stuff. And they don't want to pay the contractor for doing it, much less for not doing it. And so they say, well, let's come up with a cause. Well, to do that, they need your assistance. And the contractor, the A201 says, when any of the reasons described in the contract between the owner and the contractor, upon certification by the architect that sufficient cause exists to justify the action, the owner may terminate the employment of the contractor. Let me tell you, if you've ever been asked to sign one of those certifications, the answer is, I'm out to lunch and I don't expect to be back for the next 2 or 3 years. I'm sorry. Good luck with it. Do not sign a certificate like that until you have spoken with your contractor, you have spoken with your lawyer, you've spoken with your estate planner. I mean, that is really suicidal, and particularly where you can get in a situation where there's so many reasons under coronavirus for causes or problems. You just don't want to be the person who certifies cause for termination for cause. And you know, so you're saying, well, Stair, the contract anticipates you doing that, and you're just telling us not to do it. No, what I'm telling you is avoid it if you can. And if you can't, your certificate needs to say something that you can all live with going down the road. And I've rewritten a lot of them. But anyway, don't take lightly this certificate if it is placed in your face. It will not have a lighthearted result going down the road. All right, now, what about you? We'll work for toilet paper. Should you be doing all this for free? Absolutely not. You should not be doing this for free. There are circumstances in your contract that say where you recognize that there is a material change, you need to notify the owner with reasonable promptness, and you need to tell them what the facts and circumstances are. You need to get written authorization to proceed. You need to, what that says is anticipate. you need to communicate, and you need to document. The contract, let's see, has circumstances under which they exist. I see we're at 229, and you all, I think, will get this. You can read those things as much as anybody else. Point being is that a lot of the things we've been talking about are really set up on a big golf tee for you to hit. If you just pull them out of the contract, look at the facts as they are, notify the owner, and stay on top of it, you may well find yourself the beneficiary of some ad services. And again, we won't go over all of them at this time, but you can see them in your contract, and yours may be different. So find out what they are. And then, you have to then decide, do we really want to hit the owner up for more? A lot of people don't because of business decisions, professional judgments, and so forth. They don't want to do it. They want to delay it. They want to give the owner a break. All of that's good for relationship. Just know that when you don't do something like that, counting on somebody else to be good to you later, you may be giving up your rights. And so just make business decisions, understanding they may have legal ramifications. All right, good news. We have made it to New York. We're topping off the tower, and all is good. And what I know we have not done is talk about everything that can go wrong. What I hope we've done is given you some thought that allows you to sort of process, well, if I can see this issue here, let me see that issue there, and let me do this here. And I'm going to conclude with the question of, what does rafting have to do with all of this? Well, rafting's got a lot to do with this. I went down the Middle Fork of the Salmon River one time for a week, a wonderful experience. And what I learned is if you are in a raft and you're going through a class 4 or 5 rapid, everybody in the raft needs to be digging as hard as they can, and they all need to be doing it together. And if they all do it, then you wind up in the red raft down at the end with your tongue out laughing and having a beer and wine. If somebody, any single person in the raft doesn't do it, then what happens down there in the bottom is what will happen. And I saw that happen, and let me tell you, it made an impact on me. We spent the next 2 or 3 hours picking up people's stuff as it preceded us down the river and finally got it lodged on the bank. And it's an ugly sight. And what we're all doing is looking for something positive to come out of this coronavirus mess. And I think 2 things can come out positive. One is you and the owner and the contractor can all figure out and learn that you're in it together, and you got to have to work together. And everybody's got to communicate. Everybody's got to agree. Everybody's got to dig as a team. And you may come out with a different understanding and approach of the value of cooperation under adverse conditions that may take into other projects and into the future. Secondly, something that may happen is the things I've been preaching are something I could have preached to you February 28th before coronavirus as good practices that you just never took seriously. And now, by necessity, you may have to take them seriously. And when you come out of this mess, you're going to come out a better architect or a better engineer in everything you do in the future. And so there's another positive impact of all of this. And so everybody dig hard, learn from it all, be good to other people. And I think, we're all going to live through this. 3 things: anticipate, communicate, and document. And I believe we have reached the point of the questions. Unfortunately, we are 3 minutes over 2:30, and so I've long ended us.
Ken, it's Frank,
Yep.
And I want to thank you, and I'm sure the 275 people on this call want to thank you. It's entertaining and informative insights into how this pandemic can have an impact on both the professional and the business exposures of firms. And thank you for the advice on steps firms can take to mitigate their risk. There is one short question that I would like you to answer, and it came in, and it's an architect who says he uses an AI B101, and it doesn't really have a force majeure provision in it. Going forward, should he be adding to that a provision that says, in the case of quarantines or epidemics or whatever, there's going to be an automatic delay, automatic addition to the contract time? Is that necessary to ask the contract?
As you look back now, the answer seems to be, well, of course. I mean, you even put coronavirus in there to be even better. But no, I mean, the reality is that when you start listing with specificity the things that can constitute force majeure, what the courts then will say is, well, the things you didn't list are obviously not intended to be included or therefore excluded. Right now, I think the courts have a chance to say under force majeure, well, obviously this is a circumstance beyond everyone's control, and so we're going to rule it that way. They have that chance. Can't say they're going to do that. On the other hand, though, if you had tried to pigeonhole every kind of thing you might consider, at some point your imagination is going to run out, and then next year something else will happen that's equally as obvious to you then as something that should have been included, but it wasn't included because it wasn't obvious now. And so rather than frustrate yourself by including all of these things, I don't think I would do that. I do think, though, that if you go back to reasonable cause, for example, and of course that really deals more specifically with the design, but I think that's really the part of the project where your all's delay is going to come in the most. It really is in there that except for reasonable cause, it shall be done, and where there is material changes in the complexity and the schedule and the budget and the cost, your schedule will be adjusted, your services will be adjusted. So, again, what I don't want to do is give folks legal advice because hopefully you've got better lawyers than me who understand a lot more than I do about all these things. But I'm just thinking you're going to frustrate yourself to death if you try to envision every pandemic or everything that could happen. And so my general reaction to that is I would not frustrate myself like that.
Great. So there is a reasonable does make sense in this situation, right? Okay, well, I think it's time to close out the webinar. And again, I want to thank Kent and Tawny who's I know on the call, for sharing your expertise. And I want to remind everyone to visit our blog for the updates and to fill out the survey when it comes your way. And again, Kent, I thank you, and I think that's it for today. Bye-bye.
I'm sorry we didn't have a chance to let Tawny talk. She's